Thank you, Chair. I've listened very carefully to my colleagues, and while I have a lengthy response that I could provide based on the comments I heard from Mr. Jawari and Mr. Sousa, particularly from Mr. Sousa, without identifying myself, he certainly made specific reference to the strategy that I adopted and the evidence that I relied upon. He certainly impugned my integrity and character. And although he has parliamentary privilege within this committee, he certainly does not have it outside of this committee and outside of this House. These are serious allegations that he's leveled against me. He used the phrase obstruction and interference with witnesses. Mr. Sousa, I don't believe, has a law degree. I do, as my colleague Mr. Lawrence does. He certainly does not appreciate the rules of evidence. He certainly does not appreciate the rules with respect to talking to witnesses. And as I shared with the committee on our last occasion, there is absolutely no proprietary interest in any witnesses. That is, witnesses called on behalf of the Conservative team, witnesses called on behalf of the Liberal team, the Bloc team, the NDP team. These witnesses did not have to speak with me. They chose to speak with me. They were not under duress to speak with me. They could have refused to answer any and all questions that I put to them. In much the same fashion that Mr. Lafleur cautioned this committee in his opening statement that he was here to talk about process, but notwithstanding that opening statement, he in fact indeed answered questions. Sometimes it took me a number of times to rephrase the question, but eventually I got answers. So to answer Mr. Jawari's point, why are we doing this? I think that's abundantly clear. This is about unearthing the truth behind the wasteful spending of the $54 million ArriveCAN app, of which 11 million went to a two-person firm who's currently under RCMP criminal investigation for doing absolutely nothing, acting as the middleman between the CBSA and the real IT professionals, some of which legitimately did work, some of which did nothing and were still paid. The procurement ombudsman called that bait and switch. These are horrendous allegations against the government of Canada. So I can see, Mr. Chair, why the Liberals will do everything in their power to shut this down. Because I have chased this particular scandal over the last several months in a number of committees, and I've been faced with tactics similar to what we heard today, with motions to adjourn to silence me. I won't be silenced. Mr. Baines can laugh all he wants, but that's the truth. That's my job as a parliamentarian. And with my criminal law background and my prosecutorial background, that's how I frame my questions. I'm not Perry Mason. I wish I looked like Tom Cruise, but I don't. I thank Mr. Sousa for making that suggestion. And my wife might appreciate that in hindsight. But that's why we're here, Mr. Chair, is to get to the bottom of this scam. And in particular, GC Strategies, which just seems to be kryptonite in the hands of the government. Justin Trudeau, our Prime Minister, even said in the House that it was completely illogical, the procurement activities surrounding the awarding of this contract to GC Strategies to funnel out $54 million. If the Prime Minister has concerns, then why do not all parliamentarians have concerns? Yes, this is not a court of law. This isn't a criminal court. It's not a civil court. But Mr. Lafleur is certainly within his purview to say, yes, Mr. Brock, it's a relevant question, but it might compromise my ability to continue the investigation by answering. He never did to any of the questions I put to him or any of the questions any member put to him on the last occasion. So with all due respect to my colleagues, and in particular Ms. Vignola, who I greatly admire, I don't see how continuing with this particular witness in terms of getting some basic questions answered is going to compromise the ability for anyone to defend themselves. Mr. McDonald and Mr. Utano both have very experienced counsel working on their behalf. As I suggested to Mr. Lafleur on the last occasion, there is an application in Superior Court with respect to reasserting and preserving, their legal status and their privilege to make sure that they are in a position to participate in Mr. Lafleur's investigation. They've never refused. I know that there has been an exchange of correspondence between Mr. Lafleur and counsel as early as today, as a matter of fact. And I know that there are certain conditions that counsel wants to see established before his clients participate. And let's not forget something here, Mr. Chair.
Point of order, Mr. Chair.
Mr. Shari?
I think that statement just proves the fact.
That's not a point of order.
Yeah,
That's
it's
debate.
not a point of order. You can
You
discuss
You
it.
just revealed the
Get
stuff
on the
that's in
speaking
here.
list.
That's not right.
Mr.
Get on the
Shari,
speaking list.
I am on the
you
speaking list, and I'm going to talk about it.
You can attend to it then. Mr. Brock, continue.
Lost my train of thought there.
Mr. Shari, please.
Yeah, ad hominem attacks. Thank you. Ad hominem attacks are not appropriate. It's unbecoming, and it's not parliamentary. So thank you for your apology. I'm doing my job, Mr. Jawari.
I believe that you are doing it.
Thank you. So that being said, Chair, I believe the will of the committee is to relieve Mr. Lafleur at this time. Do you want to speak?
Yeah,
Do you want to speak?
Yeah.
Is Mr. Lawrence next on the list?
Am I next or no? I asked. Okay, must be all good, Cal.
Mr. Brock is speaking.
Go ahead.
Mr. Shari, then Mr. Lawrence,
Yeah.
then Mr. Backrack, then Mrs. Block.
So as I indicated, Mr. Chair, I believe the will of this committee is to relieve Mr. Lafleur of his responsibilities today. I take into consideration greatly the suggestion of Ms. Vignola. We're not saying never. We're just saying not now. We don't know how long this investigation is going to take. We're approaching 2 years since the date that the CBSA received the Bottler AI complaint. We've received no update at all from the RCMP, and we don't know ultimately if the investigation internally by the CBSA or the RCMP are going to focus on other individuals. As I suggested to Mr. Lafleur, which he disagreed with, Mr. Mindone needs to be criminally investigated. There is a serious allegation of deleting 4 years of relevant emails by a person who held the title of vice president, who is now Canada's chief information officer. If there's anyone who should know how to preserve their IT and emails, it would be Mr. Doan. Mr. Doan appears to be the only one at the CBSA that had a problem with his emails. That's suspicious. And notwithstanding what Mr. Lafleur said, I'm really glad we were not in camera, to Mr. Souza's point, but rather public, because I hope the RCMP investigator, whoever that was following this. because there is a strong suggestion that the breadth of those involved in this scam needs to be expanded. We've got serious concerns about Mr. Doan. I've got serious concerns about Aaron O'Gorman, the president of the CBSA, who deliberately misled this committee. Not once, at least 2 occasions, deliberately withheld information from this committee. And although witnesses are never, well, I shouldn't say never, but rarely sworn to tell the truth, there is a presumption that when witnesses attend a committee, they are presumed to be telling the truth and nothing but the truth. So help them God, or however it binds their conscience. So I leave with that notion, sir, that this investigation has the potential to be expanded, that there's more individuals involved than simply Mr. McDonald and Mr. Utano. Bearing in mind the will of the committee, I'm asking for a vote. I'm moving for a vote.